It's the Doc Talk. Yeah, we keeping it smooth. Your favorite paralegal got the legal groove. From the stars in the courtroom to your cousin's case, we breaking it all down. No rush, just pace. What's good, fam? It's your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hey, I am coming back to you guys with a Karmelo Anthony appeals update. But before I get into that, the first thing I want you guys to do, if you have not already done so, please like and share this video. The next thing I want you to do is hit that subscribe button if you are not subscribed to my channel. That way, if I post any videos or shorts or anything of that nature, you guys will be alerted on the new video. But without further ado, let's tap on into this new update. So as you can see on the screen, a docketing statement was filed yesterday morning, actually, and I have the docketing statement pulled up, but I just want to kind of go over everything as far as the process real briefly if you have not already tuned into my other videos. So once a notice of appeal is filed, the next thing to do is file a docketing statement. After that docketing statement, then if they have not already done so, they would have to request the clerk record as well as the court transcript and get all of the information that was submitted to the court, and they have to forward that to the Court of Appeals so that way the Court of Appeals can send it over to the appeals attorneys. And that's both on the plaintiff side, or I would say the appellant side, and the appellee side. What Carmelo did on the day that they sentenced him, he filed that notice of appeal because you have 3 days to file a notice of appeal. Otherwise, you just pretty much waive your right to appeal your case. And so, regardless, either he did it or his attorney did it, but they preserved that right, which is a good thing. On the 23rd, the appellate team for Carmelo filed an amended notice of appeal, pretty much saying, hey, we are we're the attorneys that are now on the case, and kind of submitted a new deadline for things to be due, if that makes sense, like kind of like a scheduling order. And then 25th, a docketing statement was filed. And here is the docketing statement. And we'll go over this in just a second, but to kind of educate you guys on what that statement is, it is a statement, it's an administrative tool that allows the clerk of the court to quickly screen a case for any procedural or jurisdictional defects. The Supreme Court of Texas has published a uniform docketing statement, which each Court of Appeals posts on its website. Each appellate court's website can be found, and they provide us with that particular website address. So going back to the docketing, this is the uniform statement, and this is for criminal. They have one for civil, but this is the criminal side. And this pretty much you have to complete to in its entirety. Okay. I've had some people reach back out to me because some people they can't afford appeals lawyers, so they try to do it themselves, and next thing you know, things are getting kicked back and they're not following the pro se guide that I provided for them. So if you don't fill this out completely, it will be getting kicked back to you. So you want to ensure that if you ever decide to appeal a case in Texas, you have to ensure that you read that pro se guide and you fill out this statement correctly. And then there's other processes that you actually have to do. But going back into this, so it shows the docket number, the Fifth Court of Appeals, the case style, the companion case, the appellant's name, the appellee's name, and then this is the all of the appellate attorneys. And so they had to check which attorney was actually sending over this file. Now he is the lead attorney, Russell Williams. So I said Williams, Russell Wilson the second. So he is the one that is the lead attorney on this case. And then going to the appellee attorneys, which would be the Collin County District Office. And so Amy Murphy is the lead attorney that is on this case. Perfection of appeal, judgment, and sentencing. So this is a criminal case type matter, and it's appeal from a final judgment of conviction. Let's see the date of the offense, the date that the sentence was imposed, his plea not guilty. Was it the trial? Was the trial by jury or non-jury? Obviously, a jury. He submitted his not guilty plea. The notice of appeal was filed on June 9th. The punishment that was assessed was the 35 years confinement to the Texas Department of Criminal Justice. And then they said, is this appeal from the pretrial order? And no. Let's see. Now, this one, section 6, it states action extending time to perfect appeal. So, motion for new trial. So, they are opting to file a motion for a new trial. The deadline to file that motion is going to be July 9th, 2026. So, they have a couple of days to get that motion in. So it's a lot of moving parts that is going on. So they have requested the records from the trial court, the court reporters, transcript, the clerk of courts, docket. So that means everything that was filed, all the motions, all the pleadings, anything that was submitted to the court has to be submitted up to the Fifth Court of Appeals. And that is how they are able to kind of go through there to ensure that every single thing was done correctly and in order. So it is a process, and it is going to be a lot of work that is done on the Fifth Court of Appeals clerk, the clerk. So not the judges here, but this is the clerk, because the clerk is trying to get all this information. um and so the clerks on both sides, the trial court clerk as well as the clerk for the Fifth Court of Appeals, because they got to transfer all the documents from one court to the upper court. So it's going to be a lot of things that they are going to get, but at the end of the day, they still have a deadline. They still have a deadline to get all of the records submitted to the Fifth Court of Appeals by August of this year. I believe it was August 8th, if I'm not mistaken. Let's see. So they already filed, and this was just saying the indigency of parties. So that is the affidavit of equivalent to the affidavit of inability to pay court costs or even afford a lawyer. So you have to. That was filed on June 9th. So that's pretty much saying that at the time he did not have the funds to actually hire an appeals attorney. And a lot of people just think that, you can just get an attorney and go, run with that. I want to be upfront and clear with you guys. Not every attorney can do things. As I mentioned before, you have like you have attorneys that are great litigators, right? But those litigator attorneys can do terrible in the courtroom. Then you have some trial court attorneys that aren't good litigators, or they are good litigators, okay? But then you also have attorneys that don't really know the appeals process. So anytime you are seeking an appeal attorney, and it's the amount of calls that I get to, help people find appeals attorneys are very, 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 it's a lot. And I don't know too many appeals attorneys. So that's why you definitely got to do your homework when you're selecting an attorney, especially an attorney that you want to help you through the appeal process. So just know, not every attorney is a litigator. Not every attorney is a trial attorney. Not every attorney is an appeals attorney. But go on and so forth. We have the trial court record, and it just shows the lower court's information. It shows the clerk's record, the reporter's record. So, like I said before, the clerk's record is everything that has to be requested, as well as the reporter. So, the person that you see in the courtroom that's typing everything that's being said, they have to get that transcript. And that's what has to be forwarded up to the actual higher court. Let me see. Now, here are some things that y'all need to see. Related matters. List any pending or past related appeals before this or any other Texas appellate court by court docket style. None known. Post conviction motion for new trial and motion to rescue are pending in the trial. I mean, not rescue. Motion to recuse are pending in the trial court. Cause number 296. Now, that is here's the thing. I'm going to go to this right quick. And I know I'm doing this on a video, but I think y'all have been with me for enough time to realize that I usually do this so y'all know, okay, she's right at work and I got to hurry up. Oh, wait a minute. You know what's crazy? Hold on. I'm sorry. I'm doing this live. Okay. So Karmelo Anthony. So the interesting thing that I just read is that they have a motion to recuse, and if y'all are unaware of what that is, that means they are trying to say that the judge needs to recuse himself from that case. So if there was a new trial, that trial cannot be heard by the same judge. I repeat, if a new trial is granted, that case cannot be heard by that judge. Why? Well, and I don't want to say it's speculation. I mean, there are photos out there that shows that the judge is friends or acquaintances, I would say rather, with Austin Metcalf's father, Jeff. So, in one of the questions that I got on one of the video posts was, why didn't the judge recuse himself? And that's a very slippery slope right there, because the judge wasn't directly, I really can't say this. He wasn't related. We don't know as far as their relationship goes. It could be an acquaintance, it's not something that maybe they called each other on the phone. But regardless, I feel that if you know this family, you should have recused yourself from that trial, or for that judge from that case, as soon as because I think this complaint was filed on June 24th, 2025. So when that came into your court and you seen these names, and you knew it was a possibility that you was going to get this case, you should have automatically said, hey, I'm going to recuse myself from this. But this is Collin County that we're talking about. This is Collin County. So, with that being said, so there's a motion for a new trial and a motion to recuse, which is pending in this court. And I didn't see that on the court docket. That's why I took y'all guys there, right there. So that right there is the docketing statement. The next thing I wanted to show you guys was, as far as the process and the reason for the docketing statement and what information it provides. It says, upon perfecting the appeal in a criminal case, the appellant must file in the appellate court a docketing statement that includes the following. So, and you saw it. So this is just a outline of what it covers. If the appellant has a counsel, the name of the appellant and the name, address, telephone number, fax number, state bar identification number of the appellant's counsel, and whether he has been appointed or retained. Okay, appointed means that the court, if he did not have the funds, then the court would appoint an attorney for him. So they have to distinguish whether he was appointed or retained. If the appellant is not represented by an attorney, then you would obviously provide their information. The date of the notice of appeal was filed in the trial court. If it was mailed to the trial court clerk, the date of the mailing, the trial court's name in the county, the date the trial court imposed and suspended sentence in open court, the date of the filing of any motion of new trial, motion in arrest of judgment, or any other filings that affects the time for perfecting the appeal, the offense charged, the defendant's plea, whether the trial was a jury or non-jury, the punishment assessed, whether the appeal is from a pretrial order, whether the appeal involves the validity of a statute, ordinance, or rule, whether a reporter's record has been or will be requested, and whether the trial was electronically recorded, the name of the court reporter, the dates of filing of any motion and affidavit of indigence, any date of hearing, the date of any order, whether the motion was granted or denied, and any other information the appellate court requires. So this, as I stated before, is something that has to be completed in its entirety. You cannot leave any type of blank spaces when you are submitting this document, or it will get kicked back. So I am glad that he got a team that actually knows what they are doing. Okay. So with that being said, I am optimistic about where this is going. I really hope that the Fifth Court of Appeals are fair and just, and they thoroughly look through all of the records, the transcripts, and everything to see if there was any error. As I stated before, one of the issues was the jury. And once they have gone through all of the court records and things of that nature, the transcripts, they can determine whether or not there are other issues. So that is the whole point of gathering all of the things that was in the trial court and submitting to the Fifth Court Appeals, because what they then do is send that over to the appellant, and the appellant creates a brief. So through all of that, through all of the transcripts, through all of the evidence that was submitted, through all of the records or the pleadings that was filed, the appellate team now will go through everything, and they will determine what issues there was, whether it was procedural or whether it was jurisdictional. Those issues will be brought up and they will be placed in what's called a brief. All right. So I may do another video kind of explaining the parts of a brief in detail. I know I kind of covered it in my previous videos, but if that's something, if you want to know exactly what the brief is the most important aspect of an appeal. I want to be clear with that. So I want everybody to understand what an appeal brief looks like, what it entails, and how it is going to, I don't want to say help or benefit, but how it will determine the outcome of this overall appeals case. Okay. But y'all let me think. Y'all let me know what you all think in the comments below. Don't forget to like, share, and subscribe. And I know, y'all, my mind goes 1,000 miles per hour. So I may trip up over something that I say. I may be like, oh, let me do this. And y'all see me go to these different websites. Hey, that's a part of what I do on a daily basis. And I'd rather be raw and uncut with y'all versus, okay, very I don't even know how to call it. But y'all let me know what y'all think about this case. Do you think that this appeal is going to be in favor of Anthony? Do you think that there are going to be other issues versus, other than the jury issue, other issues that might be brought up in the review of these records? Y'all let me know what y'all think in the comments below. Don't forget to like, share, and subscribe. Until then, I'm out. Bye.